Good morning, Mr. Broussard. My name is George Robinson. I represent ABC Oil Company in the lawsuit you and your siblings have filed in St. Mary Parish, Louisiana, alleging certain contamination on property you own. Could you state your full name and address for the record, please?
John M. Broussard, 4152 Nicholson Drive, Baton Rouge, Louisiana.
Okay. And as I understand your complaint, we're dealing with some 8,000 acres in the Appellate Basin.
Yes, sir.
Okay. I'm going to show you a document which is marked as Exhibit 1 for identification attachment to your deposition. This appears to be a judgment of possession rendered by the 16th Judicial District Court in St. Mary Parish in favor of you and your siblings who are plaintiffs in the lawsuit. Do you recognize the document?
Yes, that is a judgment of possession under which my siblings and I inherited the property that's under litigation from our parents.
Okay. And when was that?
That was in 1985.
Okay. I want to show you what we have on the easel, which has been marked as Exhibit 2 for identification and attachment to the deposition, which purports to be a 1998 aerial photograph of a certain portion of the Appellate Basin in St. Mary Parish. Do you recognize that aerial photo?
Yes, sir.
What does it show?
That shows what our attorneys refer to as the north area of the property as contrasted with the southern and central areas of the property that's involved in the litigation.
Okay. So, Mr. Broussard, is this one of the areas that you contend you and your siblings was contaminated by my client's oil and gas operations?
Yes, sir.
Okay. Can you identify the Appellate Basin levee for me?
Yes, I can.
Okay. Thank you. You're pointing to the basin on Exhibit 2.
Yeah, that's correct.
Thank you. Let me show you now, sir, what's been marked as Exhibit 3 for identification and attachment to your deposition, which appears to be the complaint that was filed in the United States District Court in Lafayette. Do you recognize that?
Yes, sir.
Now, you've alleged, and your siblings, in the complaint, that there were large saltwater or produced water disposal pits located on the property and which have caused the property to become contaminated with chlorides. Is that correct?
Yes, sir.
Okay. Can you show us on Exhibit 2 where that large pit is located?
Yes, sir. The large pit is located right here on Exhibit 2 on the left side of the photograph, which is on the west side of the basin.
Okay. I'm now going to direct your attention to the east side of the levee, to the large body of water, which I'm going to point to and ask if you can identify that.
Yes, sir. I don't know for certain what that feature is, but we think it's another pit.
Okay, do you know that for a fact?
No, I don't.
Okay. Can you identify for us the areas where you contend the additional pit operations were?
Yes, sir. It's right here on Exhibit 2 where I'm pointing.
Do you know if that's an emergency pit?
Yes, it was.
Okay. All right, what's the next pit area that you contend was contaminated or caused contamination?
Here, we believe that was a pit of salt water left by the oil company.
And is that's part of the contamination you and your siblings allege in your lawsuit?
Yes, sir.
Okay. Now, do you know whether there were oil wells on the property?
Yes, sir. I think I do.
Can you identify them by pointing to them with the pointer on Exhibit 2, please?
Yes, sir. The wells are in these two places that I'm pointing to on Exhibit 2.
Were there other well sites?
Yes, sir. There were two other well sites.
Would you point those out for me?
Okay. The other well sites are right here and here on Exhibit 2.
Thank you. Now, do you know where the production equipment is located?
Yes, I do.
Could you point that out for us on Exhibit 2, please?
Yes, sir. Excuse me. It's right here.
Okay. And to your knowledge, that's where the production equipment was located?
Yes, right here on Exhibit 2.
Mr. Broussard, thank you for your patience, sir. I have no further questions. Mr. Broussard, good morning. I'm George Robinson. I represent ABC Oil Company and the lawsuits you and your siblings have filed alleging contamination on certain property you own in the Appellate Basin in St. Mary Parish, Louisiana. Could you please give us your full name and address for the record, please?
John M. Broussard, 4152 Nicholson Drive, Baton Rouge, Louisiana.
Okay. As I understand it, sir, we're dealing with about 8,000 acres plus or minus in this lawsuit.
Yes, sir.
Okay. I want to show you a document which I've marked as Exhibit 1 for identification and attachment to your deposition, which appears to be a judgment of possession rendered in the 16th Judicial District Court in St. Mary Parish, Louisiana. Do you recognize it?
Yes, sir. This is the judgment of possession under which me and my siblings inherited the property that's in litigation from our parents.
Okay, and that was in 1985?
Correct.
Okay. Now, I want to show you what I marked as Exhibit 2 is on the easel here in front of us. And I ask you, it appears to be a February 21st, 1998 aerial photograph of the Sherrington Field, or part of the Sherrington Field. Do you recognize that photograph?
Yes, I do.
What does that depict, sir?
That shows what our attorneys in the lawsuit refer to as the north area of the property, as contrasted with the southern or central areas of the property that's involved in the lawsuit.
Now, can you identify the Appellate Basin levee for me?
Yes, sir, I can.
Okay. And you're pointing to the large red line?
Yes.
And is the levee marked at its western, approximate, central, and eastern ends with a dot containing the number 1?
Yes, sir.
Okay. Now, I will show you what's been marked as Exhibit 3 for identification and attachment, which appears to be the complaint you and your family members filed in the U.S. District Court in Lafayette. Do you recognize that document?
I do. Sure.
Okay. Now, the document, or the complaint, alleges in Article 2 that there were large saltwater or produced water disposal pits on the property which have contaminated the property with produced salt water or chlorides. Is that correct?
Yes, sir. Yes. Mm-hmm.
Can you tell me where that large pit is located and identify it by the number on Exhibit 2? Excuse me.
Yes, sir. It is marked as number 2 right here, which is on the left side of the photograph, and it's on the west side of the basin.
Okay. I direct your attention to the east side of the levee, to the large body of water marked with the number 3. Do you see that?
Yes, sir, I do. I don't know for certain what that is, but we think that is another pit.
Okay. Do you know that for a fact?
No, sir, I don't.
All right. Now, Mr. Broussard, can you identify for us on the exhibit by numbered location, if you will, where the other contaminated areas are?
Yes, sir. Right here, number 4 is 1.
Do you know if that's an emergency pit?
Yes, it was.
Okay. Now, I direct your attention to Exhibit 5. Can you spot that for us on the exhibit?
Yes, sir. It's right here, right there, and that's where we think a saltwater pit was left by the oil company.
Okay. And again, is that part of the property that you and your siblings contend in the lawsuit was contaminated by my client's operations?
Yes, sir.
Now, do you know, Mr. Broussard, where the oil wells were?
I think I do.
Okay, can you identify them by the numbered areas on the exhibit?
Yes, sir. They are numbers 6 right here,
Okay.
and number 7 right there.
Okay. Now, there were 2 more wells located in that area?
Yes, sir. 2 more wells.
Okay, and did you draw a red arrow from the number 7 to each of the other 2 well sites?
I did. Here's 7, and I drew it from there to here, and from there to here.
Okay, now can you identify the production equipment for us?
Yes, sir, I can. Let's see here. The production equipment is marked with, right here, the number 8, and then there is a P immediately to the left of that number 8.
What does that P represent?
It represents production equipment.
Okay. Mr. Broussard, are there any other areas depicted on Exhibit 2 that you and your siblings contend were contaminated by my client's operations?
No, sir.
Are there any other pits which are not marked, to your knowledge?
No.
Are there any other wells on the property which are not marked?
No, sir.
Are there any other areas on this exhibit, Exhibit 2, that you and your siblings contend was contaminated by my client's operations?
No, sir.
And Mr. Broussard, I understand that you essentially are testifying on behalf of all of your siblings because you're the one that has the factual knowledge of what went on the property.
That's correct.
And the contamination.
Yes, sir, that's correct.
Thank you, sir. I have.
George, if you had just that first vignette and never did a better job, as you did the second time around, but just had that first vignette, and you went to court with that, what problems would you have run into?
I think your problem starts in that type of case with where you're dealing with contamination. Your memory's not going to be good enough to let your experts go in and sample those areas. Moreover, when you get to trial, the plaintiff has got pretty much free rein to change his testimony, Mr. Broussard, because nothing is marked. He can add pits, he can add contamination, he can add wells, he can add areas that he now contends, since the deposition, are additional contaminated areas, and his siblings can get on and essentially pile on by saying, oh yeah, we knew this area over here was contaminated. So your ability to effectively cross-examine the plaintiff is the primary disadvantage you put yourself at by not marking the exhibit, and this really applies to any type of exhibit.
Dave, what do you think?
Well, I think the principal mistake that inexperienced lawyers make is that because they gain the information at the time of the deposition that the process is adequate. And the purpose of the deposition isn't to personally learn, it's to build a record. We're doing a deposition for the purpose of establishing on the record facts that we can rely on for the experts and at trial. And here, when the witness pointed, the questioner certainly learned and understood, but that understanding is not on the record. So I like to tell newer practitioners that they should, in their mind's eye, read the record as it's being created, as opposed to listening what's occurring. And if that lawyer in the first vignette had shut his eyes, shut off what he was hearing, and simply attempted to read the record that was being established, he would have known that there was nothing there that could be used. And that's the essence of what needs to be accomplished here. The other point that I think that we see in the second vignette is that the lawyer has spent a little bit of time in advance of the deposition, both pre-marking the exhibit and potentially even working with the witness off the record, so that the second vignette went very quickly. It doesn't take a lot of additional time on the record, on the video, once that extra preparation has taken place. So both preparing to demonstrate the evidence on the record and then making sure that the record reflects what is being learned is the essence of what the second vignette shows us.
Yeah, I think I'd chime in and say, with respect to using exhibits, and Dave and George have referred to pre-marking them, a good way to do it is if you're going to use 20 exhibits or 50 or whatever they are, just put tabs on them from the very beginning, 1 through 50, and have copies made. And otherwise, you get to the deposition, you've got one set of exhibits, and other lawyers want copies of the exhibits, be able to pass out each one as you're using it, and it's amazing how much time you will save at the deposition and how much more in control you will be. And there's nothing wrong if you get there and you use the first 3 exhibits and then you decide you're not going to use number 4. There's nothing wrong with saying, I'm going to skip number 4, here's number 5, or I'm going to skip 5 and come back to 4, whatever you intend to do. I personally like to follow the practice of starting with exhibit number 1 and going as far as you go, and trying to convince my opponent to go along with that practice. If he or she wants to start at 1001 or some other number, that's fine, if you want to be able to identify which side used which exhibit first. But very often, exhibits will be marked either P1 if the plaintiff is using it, or D1 if the defendant is using it. And there's really no particular reason for that. Or sometimes people will say, all right, the name of the witness here is Azenbray, we'll make this Azenbray 1. And then you ask the witness what it is, and he says, I have no idea, I've never seen it before. So now you've got a document that the witness says he never saw before, and it's got his name on it. And I think there's a potential for confusion. And I do that as a basis, by the way, of when I get to trial, try to keep the same numbers so that when you use the deposition transcript and the witness is questioned and answering about Exhibit 37, you don't have to explain that, well, now it's Exhibit 88. Just keep the same numbers. If there's some you're going to drop, just drop them. And if there's some you're going to add, pick up where the deposition exhibits ended. In the long run, again, I think it makes your life easier, and in fact, it makes everybody's life easier.
The way I like to put it is that there's only going to be one number 1 in the case. The first time you mark an exhibit as number 1, the next exhibit's going to be number 2. And even though you may have a second deposition, you're not going to go back and create a new number 1. Otherwise, you might have 5 or 10 number 1s, and then a different number 1 at trial, and it becomes extraordinarily difficult for the jury to sort all of that out. The record will stay clear if there's one number 1 and one number 2.
You know, Dave, in terms of seeing the transcript, now, of course, you can, in fact, literally see it on the screen with the systems that they have as the deposition is going on. But I thought it was an advantage. When I started, lawyers generally did not type their communications as they do now. You dictated things, and you learn to see the dictation. As you're saying it, you could see it going down on the page. And I thought that was a big advantage when it got to depositions, because you're hearing it and you're seeing it go on the page at the same time, and you can see whether it matches up or it doesn't. Not that we can turn back the clock here.
Another good example of making sure that we have a clear record is not only that it's on the record, but that it's unambiguously on the record. So, for example, in the vignettes that we just saw, if the witness was asked whether the event had occurred on the left side of the page, if the witness said right, we have to sort out whether the word right means right in the affirmative or right as the opposite of left. Otherwise, we have an unambiguous statement that is understood in the room become an ambiguous statement on the record. So you have to not only listen to what's being communicated to you, but you have to be visually in your mind reading what's going on the paper and asking yourself, is what is being placed on the paper complete and unambiguous and specific to the question that I ask, or have we created something which is vague and potentially unresponsive to what I ask and potentially ambiguous in that it can be taken in more ways than one?
Dennis, you mentioned control in terms of pre-marking depositions.
Exhibits, yeah.
Exhibits. But if you do that, what I like to do is put my copy in a binder. And I've got my outline there. I've got copies to hand the witness, copies for opposing counsel. It makes you look in control to the extent it's an intimidation factor. It's to your advantage, and it allows you in your questioning to establish a rhythm where you move right along and you look organized. And to that extent, I think it's an advantage tactically.
Yeah, and I think a lot of times if you're going to be questioning about an exhibit, and there's no one right way to do this, of course, but very often just physically writing your questions on the exhibit itself, on a work copy of the exhibit, is a whole lot better and easier to work with than you have a nice clean document here and you have your notes about what you want to ask over there, and it becomes hard work to match them up as you're going along.
I like to do that with expert reports. You've got the report in front of him and you've got your outline, but it's also helpful on the key points on his assertions or his opinions to jot down your key questions.